Judge, some of these folks have come in. I don't know if Mr. Hall was in here when he was on my Friday jail visitation that I had to cancel. We've taken depositions. I don't believe everybody showed up but in June on this case, but he has a new case that's scheduled for arraignment on August 18th.
So you want to put this on August 18th too? Is that what you're saying?
Yeah. And I will go out and see Mr. Hall. I can't remember if an information was filed on the new case or not.
Not yet, but I will be.
So, sir, that you've already got a date for you heard what Mr. Mayor said, you've already got a date for August 18th. So that actually moves you a little ahead of the line because otherwise it would be later in the month. We'll make sure this case goes with your August 18th case. Mr. Meredith will talk to you about any offers or any kind of deals.
I'll be out. Mr. Thomas. This is Jadicus Thomas. He was on my Friday jail visits, which I was not able to make. There's a violation of probation. I don't know if we need to set an evidentiary hearing. The only offer is prison. So.
Did you say you want to set it for never, or it is set on one?
It hasn't been yet, but
We need to set it for one, Your Honor.
Say that again, Jackson. I'm sorry. You need to do.
Can we please set it for one, Your Honor?
Yes, absolutely.
August 20, I believe, is the violation of probation day.
And do you usually put all the cases on that same date? Yeah. Okay, that's what I would suggest. But so, Mr. Thomas, what they're talking about is actually having a hearing where the state will have to try to prove you're in violation of your probation on that day. Won't have a trial on these other cases, but they'll be on that same day so they can be contemplated. Okay. Do you have any questions about that? Mr. Meredith will be out to see you before then.
I will. I apologize.
Is that the right date, Debbie or Jill? August 20th?
August 20th.
Okay.
Yeah. We'll talk. And Mr. Warley? And Judge, in Mr. Warley's case, we were appointed last month. He had private counsel prior to that. I'm scheduling depositions. He was on my Friday list to go see. I had an issue with my wife, so I apologize. So I'm going to go see him as quickly as possible. I'm not sure what date we have for depositions. The only offer is 5 years, 5 months, Department of Corrections.
So you've got depots set, or
I've requested depositions. When I left the office this morning, I didn't have it.
do you know, Jackson, if you have some set?
I don't know, but normally, the way that our depots work, it takes about 3 months to get on a depot. Can we have the November trial docket?
Can we come back in September so I can?
We'll do that.
It puts me on the.
Yeah, we can go to September pretrial. Sir, doesn't mean you're going to get right faster than that November date the state's asking for, but you could. And maybe after depots, maybe things will change. The posture of the case will change. I don't know.
I'm in there for no contact. I've been here 6 months in jail, so out for probation or something, but
I know, but the state's only offering you prison at this point.
yeah.
So the only way you can change things today is to say, I want to take that 65 months. Mr. Meredith doesn't think that's a good idea at this point.
I don't. He had bonded out, and there was a motion to revoke his bond prior to us being appointed. I really had hoped to see of all the clients, I wanted to see Mr. Warley because I hadn't met with him before.
Mr. Worley, so Mr. Meredith, when he meets with you, tell him all that stuff that you want him to know, and he can check on your bond situation too. Okay.
Yeah.
So we'll go ahead and set you for August 21st. September.
No, August 21st is good.
I think
way
that.
I'll be sure to see him within the next 2 weeks.
Yep. Okay, Mr. Worley, take care.
Thank you.
I don't think I've seen any of the four guys on the front row.
I've got three of them.
Okay, Barbie,
All right, so we've got Jason Addison.
come on up, Mr. Addison.
His case number is 243997. We're looking for some discovery, and then after we see if we can find, we're looking for some dash cam, then we may be in a posture to resolve the case. So if we could pass it either to August or September.
Well, you know me, if I get the choice, I'm always going to say the first date.
September is fine, because I think for the most part, we've worked through a lot of the depots. We just have a couple of things left.
Right.
Except for a trial before the.
Barbie, you're okay with September?
Yes, Your Honor.
Mr. Addison, it sounds like the attorneys think they need to that September date to maybe come to some kind of resolution. If you come to a resolution before that, they all know how to get you back in front of the court, okay? So we'll move you to September the 18th. And Ms. Beasley's working on your case for you.
Sean Golden. This is with Mr. White. Mr. Golden's case is case 243310. We're working on getting a defense witness together, so we need some time to do that. If we could return in September.
Your Honor, we've had depots on the most important witnesses. In this case, the state's position is not budging. We need to get this moved to a trial.
What's your name, sir? I'm sorry.
Sean Golden.
Golden. I mean, we certainly can go to a trial date, but you might want to have some interim date in between there. What trial date, what are you thinking, Jackson, for a trial date?
As a practical matter, I don't think we can get this actually tried until the November date.
So Ms. Beasley's just asking for a pretrial in between. Why don't we just set it for a pretrial and then let you go from there?
If we could come back in September and we can go ahead and put them on the November trial
Okay,
docket,
let's
and
do
that'll
that.
give us time to get that witness and give Mr. White an opportunity to set the deposition.
So the states want me to go ahead and put you on a trial docket, which makes sense, but not until November. But we're going to bring you back on September the 18th and see if things have happened between now and then. Do you have any questions?
No, sir.
Okay, take care.
Tyrone Jackson. Your Honor, this is Mr. Jackson. He has two cases before you. First one is 214910, which is a BOP. He's going to enter a denial on that BOP. And then case 243750, he's going to plead no contest to count one, felon possession of ammunition constructive. That's a second-degree felony. Maximum penalty is 15 years in prison. His violation case is a third-degree felony. Maximum penalty is 5 years in prison. Count 2, 3, and 4 in case 243750 will be consolidated into count 1 for purposes of the plea. Probation is revoked. He will serve 26.4 months in the Department of Corrections with credit for 413 days. In the new law case 243750, he'll serve 26.4 months in the Department of Corrections concurrent with the violation case with credit for 413 days. He'll have court costs and fines in the violation of probation of $250, $1,028 in the new law case. And those will be reduced to a civil judgment. And we would also request for a local placement, possibly Bay CI.
I heard you say at the beginning, you said a denial on the BOP.
Oh, I did admission.
Okay.
Just, yeah.
I was
I'm
throwing
sorry.
out saying, how are we going to sentence this man if he's denying it? Sir, do you understand what your attorney said?
Yes, sir.
So the sum total of it is all that 26.4 with credit for 413, right?
Correct. Yes, sir.
I hadn't done the math, but you've already knocked out a year and a quarter out of that, right? Are you under the influence of any drugs, medications, or alcohol?
No, sir.
Are you being forced, threatened, or coerced to enter this plea?
No, sir.
Has anybody promised you anything other than what Ms. Beasley just related to the court?
No, sir.
You understand as to the VOP, it's actually an admission, not a denial, right?
Correct.
Okay. And you understand you're entitled to a hearing on that if you want on the VOP, but you want to go ahead and resolve it today altogether.
Yes, Your Honor.
Makes sense to me. Is there anything about you today, sir, that would keep you from understanding what's going on?
Yes, sir.
Okay. Is this everything you've got out there?
Yes, Your Honor, this
On
is
the-
all of his pending cases.
Okay. Score sheet, y'all agree that it's correct?
Yes, Your Honor. I know Mr.
There's
Herrera redid the calculation.
There's no DNA flying around out there we need to worry about?
No, Your Honor, the defense is not aware of DNA.
I tell you, Mr. Jackson, every time I get a case, I think they slip in a couple extra pieces of paper for me to sign. So I'm going to find your pleas freely and voluntarily made with knowledge of your consequences. There's a factual basis based on the agreed upon facts, which does result, of course, in your admission and the revocation of your probation. In the probation case, your probation's revoked your adjudicated guilty sentence of 26.4 months. Prison with credit for 413, that sentence to run concurrently with any other sentence, including the one I'm about to impose on the felon in possession of ammo. That's 24,370, 3750. In that case, your adjudicated guilty sentence to 26.4 months concurrent to the other sentence with credit for 413 days. Your fines, fees, and costs total $1,028. You'll forfeit any seized contraband items. You'll submit, of course, to a DNA sample and fingerprints. Do you have any questions?
No, sir.
All right, sir. You take care of yourself. When you get out, try not to come back, okay?
A recommendation, Your Honor, for.
Yes, I'm sorry. We're recommending local placement, maybe BCI. Local around here, though, there's places in Washington County, Jackson County, Calhoun County, Holmes County. We'll get you somewhere close here, probably. All right. Take care, sir.
All right, let's talk about that. This hearing ran the full spectrum from quiet calendar coordination to full-on sentencing. And at the center of it all was a judge keeping things organized, on schedule, and fair across the board. No theatrics. Just real people navigating real consequences. It opened with Mr. Hall, whose cases are now synced for August 18th. The defense noted depositions have already started, though not everyone showed up for the first round. He's also facing new charges, but nothing seemed particularly tense, just moving parts being lined up. The judge made a point to say this actually bumped Hall up in the line, which is about as close as we get to courtroom optimism. Then we moved to Jadicus Thomas, facing a violation of probation with no plea deal on the table, just straight prison. His case was set for an evidentiary hearing on August 20th, where the state will have to prove the violation. The judge explained it clearly. No trials that day, just a focused hearing on the probation issue. The tone was firm but understanding, with Mr. Thomas expressing no confusion and the court making sure he'd meet with counsel before the date. Mr. Warley's case stood out next, not because of anything dramatic, but because of a candid moment. He's been in jail for 6 months on a no-contact order, and the only offer on the table is 65 months. Doc, his lawyer, apologized for missing a visit and emphasized the need to talk things through. The judge acknowledged Warley's frustration, but reiterated that without a better option, nothing could move forward. They scheduled him for August 21st, and the judge reminded him, if something's going to change, it'll come from the defense side, not the court. Next up was Jason Addison, whose team is still waiting on dashcam footage. Nothing was resolved yet, but both sides agreed to move it to September 18th, in hopes the outstanding discovery will allow for resolution. Then came Sean Golden's case. Now this one had more bite. The defense wants more time to secure a witness, but the state is adamant. They want this to trial. No more delays. A compromise was reached pretrial in September, trial in November. That gives the defense time to work, but also satisfies the court's need to keep things moving. Finally, Tyrone Jackson's case wrapped things up with a full sentencing. He pled no contest to a charge of felon in possession of ammunition and admitted to a violation of probation. The outcome, 26.4 months in dock, with credit for 413 days over a year already served. The judge clarified everything from concurrent sentencing to court costs, and even made a note to recommend local placement to keep him close to home. Mr. Jackson was respectful and engaged throughout, and the hearing ended with a sincere try not to come back. In all, this hearing was a showcase of how the justice system works when it's functioning like it should: deliberate, procedural, and when possible, compassionate. The judge offered structure without pressure, and defendants got the space to be heard without derailing the process. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.